Hello, everyone, and thank you for joining us today for this webinar. Before we get started, I have just a few housekeeping notes. For the benefit of all participants, attendee lines have been muted, so if you should have any questions that you'd like to submit during the event, please submit them through the question and answer space. We'll do our best to answer questions as they come up, but we do have a lot to get through today, and if we cannot answer your question during the webinar, we will follow up after the program to make sure that you get an answer. Please note that today's webinar will be recorded and circulated to all registrants via email after the event. Should you have follow-up questions at that time, please reach out to any of the key contacts listed in the email communication. A note that Dentons can only issue CLE credit for attendance during the live broadcast of the webinar. Participation on the live webinar must be on a computer or laptop device. Credit is not available for joining via a mobile device. One last important note, if you have a New York or New Jersey license, please be sure to listen for the code word given during the program. When prompted, you will need to enter that code word into the Q&A section of the screen. So with those housekeeping notes out of the way, I'll turn it over to Joe to let's get this kicked off.
Okay, well, good afternoon to everyone except those on the West Coast. So good morning for you. Thank you all for joining us for our first quarterly Dentons Academy. So for those of you new to Dentons Academy, we try and do them about quarterly, but internal or trainings for clients and friends of the firm on various topics. Today, Austin and I are pleased to present to you a 2025 year in review. So we can move to our next slide. This is me, Joe Martinez. I'll be one of your presenters today. I'm joined by Austin, one of our associates. Contact information is there. If you have questions, please feel free to reach out. So the things that we're going to cover today, I think as Austin already mentioned, we have a fairly full agenda, so we'll move a little quickly, but please feel free to ask your questions through the chat function. We'll do our best to answer those. If we don't get to anything, we'll try and catch them at the end. So for 2025, we'll start with just a discussion of some key themes that were prevalent through 2025. And then we've broken some of the updates into just sort of general thematic areas. The first we're going to talk about is the FAR revolutionary reform and overhaul process that is underway. And we'll also have some regulatory and case updates on cost and pricing issues, data rights, cybersecurity and artificial intelligence. A1 is some people call this artificial intelligence. Sorry for the digression. And then we'll talk about bid protests as well and give you a few updates. So I'm going to start with key themes. So I know from the attendee list, many of you are deep in the acquisition community, government contract lawyers or others supporting well-established government contractors. For those of you who aren't, maybe you haven't followed this as much as those who live and breathe this every day, but 2025 was an exceptionally busy year for acquisition reform. One of the key drivers for that, and something that was a little unusual, was just the number of executive orders that the president issued specific to the acquisition system itself. I've kept real great statistics, but in a typical year, you might see one or two executive orders that touch on procurement issues, maybe fewer over the last several years. In the Biden administration, we saw a couple related to things like sick leave or minimum wage for contractors. So executive orders are typically a way for the administration to signal things of their agenda, their priorities. We got quite a few of them in the first year of the Trump administration. Several of those are highlighted here. A big one that was not specific to the acquisition community relates to regulatory agenda generally, and a viewpoint that the federal government overregulates, and that in any promulgation of new regulations, the government should look to remove existing regulations, just given how heavily regulated our industry for government contractors is. That's likely to affect us. But that one was more of kind of general application. And then there were a few very specific to government contracting. Interestingly, a lot of them really prioritize commercial items. They all kind of start off with a recognition that this is the existing federal law. It's been federal policy for coming up on 30 plus years that the government should acquire commercial items. And I think there's long been a recognition emphasized by the president here in these executive orders that that has been overly aspirational, that we're not actually acquiring commercial items to the degree that the government should be, that the government is spending too much money on developmental items. And really the primary concern, I think both financially that's costly and is expensive, but is it's very time consuming. That there is a sense that there is a whole ecosystem or economy out there that the federal government is unable to tap into, that commercial solutions are available to be purchased, and they're not acquiring them because the government isn't properly focused on the acquisition of commercial items. So that was brought up in several executive orders issued by the president. Second key aspect of that was not only the focus on commerciality, but then a similar focus when they are doing non-developmental, I'm sorry, I should say developmental items, that the government should do that through other transaction authority where it can. So a lot of emphasis on changing the existing procurement system, either by using commercial items to do it, quicker, faster, cheaper, or using OTAs to circumvent the system. So you'll hear that kind of repeated throughout a lot of the updates. That's why it's a key theme. So we can move to our next slide. The NDAA, so the 2026 NDA is passed, that goes by fiscal year. So that was actually passed in December of 2025 and signed into law. The NDAA typically has a section 800 that deals with all kinds of acquisition related issues. And then other aspects of the NDAA also highlight government priorities for Department of Defense. So spending, program, and then acquisition issues are addressed. Again, I think a continuation of the themes that the president started through the executive order is an emphasis on streamlining the acquisition process. So finding new ways to acquire items. A big part of that was raising fairly significantly the thresholds for either the submission of certified cost or pricing data, as well as compliance with the cost accounting standards. That threshold will now go up to $100 million. Again, I think reflective of two issues. One, just an idea that that number periodically has to be revised, just inflationary effects. Periodically, the government raises it. I think here that was a quite significant bump, a doubling from 50 to 100 million, is trying to reserve the more onerous, I suppose everyone would probably agree with the characterization, regulatory requirements for government contractors really on the dedicated large contractors, and avoid having those heavy regulatory burdens shared by either commercial item contractors or those who are not fully engaged in only doing government contractors, so smaller players, again, consistent with that idea that there's a lot of companies out there who aren't selling to the federal government, who ought to be tapped into to provide new innovative solutions to various government problems, in this instance, largely focused on defense. Okay, we can move to our next slide. In addition to regulatory and statutory, a number of enforcement priorities have been identified as a key theme in 2025. Again, I think for those of you that are kind of fully ensconced in government contracting know CMMC, or the cybersecurity requirements for contractors and subcontractors, is what final rule was issued. It's coming to fruition last fall. It's being rolled out that contractors have to have their self-certifications, their audits done. Austin will talk more about that when we talk about specifics, but there's been an enforcement priority on CMMC and cybersecurity compliance, as well as a number of issues in fraud initiatives. One issue of specific concern to those of you either who are small businesses or deal with small businesses in your supply chain, and something that caught a lot of kind of news attention and entered into the discussion. The executive branch basically required an audit of all A2A program participants. So 8A is a small business set aside. So it's a program. Once you're a small business, you can join the program. There are specific contracts that are set aside for participants in that program. And there's been a perception that there is a significant amount of fraud or impropriety tied to that program, really with contractors that don't otherwise qualify. A lot of the SBA is based on self-certification. And so there's been somewhat of a stand down in a sense to actually go audit and ensure compliance. So that has been something of particular interest again to the government contract community.
Next slide, please. Thank you. So first, we're going to dive in a bit more to FAR reform and procurement overhaul, discussing some of those executive orders that Joe mentioned, as well as the revolutionary FAR overhaul. Next slide, please. So these are some of the themes of the executive orders, and up there we have four of the major ones that have started a lot of this process, and they do kind of interact with each other. They're clearly all aimed at making things more efficient, at stripping out parts of the procurement process that the administration views as burdensome to itself, to contractors, that slow things down, that don't allow it to be as agile as it would like to be. Next slide, please. So one of those, Executive Order 14240, a consolidation of domestic procurement functions under the GSA. That's really the goal of this. Again, the goal is to reduce waste, to consolidate procurement functions within the GSA so that there aren't duplicates or redundancies across agencies. Later in 2025, the GSA created the Office of Centralized Acquisition Services specifically to fulfill the promise of this executive order, a kind of cross-agency support office that is intended to aid agencies as they transition procurement in accordance with this executive order. So this executive order requires consolidation plans to be submitted to OMB, and then designate or provide a way for agencies to procure through those comprehensive plans instead of on their own. Next slide, please. Similarly, or kind of in the same lines, Executive Order 14271, the goal is to eliminate wasteful spending, to accelerate integration. This is part of that commercial first directive. It's one of the executive orders that instructs agencies to stop defaulting to government unique purchasing, but to use commercially available products and services. It signals more use of FAR Part 12, which does govern commercial acquisitions. Contractors are also instructed to clean up their commercial item determinations and make them easier to be adopted throughout agencies, across agencies, and again requires some annual reporting on that. Later in 2025, after this, the OMB did issue a memo intended to assist agencies in completing that reporting. So it directs them as to what should be included in the report. It even provides a template on how things should be reported. As it goes on, we'll see what the outcomes of that reporting are, and if things are streamlined and if more commercial procurements come of that. But at this stage, it involves a lot of intragovernmental activity. Next slide, please. So Executive Order 14275, this was the executive order that kicked off what is being called the revolutionary FAR overhaul, called that by the government. It directs agencies to, it directs a review of the FAR, and one of the directions is that after the review, the FAR should only contain provisions required by statute or essential to sound procurement. And in fact, there is a regulatory sunset that's included in this review as well, which suggests that FAR provisions that are not required by statute, if they are still included in the FAR even after this review, those FAR provisions should be sunset 4 years after the final overhaul rules are published. So again, the goal here is to really streamline the procurement process to strip out things that are viewed as unnecessary or detrimental to the government's ability to procure in an agile and a quick way, and eliminate burdens kind of across the board. Next slide, please. So FAR overhaul, as I'm sure many of you are well aware of it, it's been a year-long process. It's not completed, so we'll see if that turns into a years-long process. To overhaul the FAR, to strip out, again, unneeded provisions. How this process has gone is that each part of the FAR has been received a piecemeal overhaul, each part one at a time. And then deviations are issued. There's a model deviation text issued that says this is what we think the FAR will look like after the overhaul is done. And then agencies are free to adopt and implement that model deviation text through a class deviation. At this time, all of the FAR parts have received model deviation texts. Part 2 and 52. Part 2 contains definitions, and Part 52 contains contract clauses. Those have not been finalized and completed, but all other parts have at this time. One important note that we make there, so the Department of Defense, Department of War, issued class deviations, and those deviations made adoption of the model deviation text effective February 1st, 2026. So phase 2 of this process is going to be implemented throughout 2026. We'll see where that ends up and how the rulemaking process continues now that most of the text has been amended, but it remains to be seen exactly what the final revisions will be and if they'll be any different than the model deviations that have been issued over the last year. Next slide, please. As Joe mentioned in the beginning when discussing key themes, the 2026 NDAA increased thresholds. This slide talks about the threshold increases for cost accounting standard applicability. So prior to the 2026 NDAA, full CAS coverage applied for a single CAS covered contract award of $50 million or more. Sorry, a single contract of $50 million or more would be CAS covered. Or if a contractor received $50 million or more in CAS covered contracts during the preceding accounting period. That is going, and then there's also modified CAS coverage, which was a much lower. If we go to the next slide, please, we'll see the increases in those thresholds. Full CAS coverage goes up from 50 million to 100 million, doubling, and now modified CAS coverage applies to contracts over $35 million. The threshold for that was much lower previously, $7.5 million, so quite a significant increase, taking out a lot of contracts which might have otherwise been subject to those requirements. Again, the takeaway really is that this is a win for small and medium-sized contractors who do business below that threshold. The CAS requirements can be quite onerous, and so taking out a large population of contracts should reduce compliance burdens for a good number of organizations. Next slide, please. if we could go to the next slide, that would be great. Thank you. So last executive order, and this is a bit more recent, 14372. This is a really directs a review of currently, previously awarded contracts, current contracts, um, and directs a review to see whether contractors are underperforming and have engaged in one of a number of behaviors that the administration views as perhaps not sufficiently focused on improving the contractor's own capacity, and instead engaging in, stock buybacks, other kind of financial activity. So specifically, again, contractors that haven't invested in their own production capacity or are not prioritizing U.S. government contracts, though it's not completely clear what it means to not prioritize a U.S. government contract. It's unclear exactly, what the end of this review process will look like, or what kinds of contractors will be identified, especially under some of the more subjective criteria. One potential comparison that may provide some insight into how this review process will proceed was last year's executive order on DEI programs. In that executive order, there was a similar review of outstanding contracts to review whether contractors were engaging in DEI programs that were in violation of federal anti-discrimination law. Contractors received requests to, first there was a review to see for the government to see, do we see any DEI programs that may be in violation of federal anti-discrimination law? They communicated with contractors to say, hey, we see this. Tell us why this isn't in violation of federal anti-discrimination law. There were modifications issued. Some contracts and grants were canceled. We could see a similar process here, again, because it is a review is directed first and then action will be taken after that review. But it's not totally clear how this will proceed. Next slide, please. Along with the review, and again, this is similar to last year's DEI executive order, along with the review, there are some new contract provisions that are expected to be included in new contracts and may be added to current contracts through modification. Provisions prohibiting stock buybacks, and provisions around the structure of executive compensation. Again, the administration signaling that it's going to be more involved in the specifics of how contractors operate, what they are and aren't allowed to do. So again, the process we could expect it to be the same. There were new DEI provisions modified into contracts, included in new contracts. The process could likely proceed the same way here. Next slide, please. So this is our code word. If you're licensed in New York and New Jersey, please type and submit the CLE code word, which is pricing. Code word is pricing in the Q&A box on the right side of the screen. If you do not find the Q&A box on the screen, click the More button and select Q&A. And if you don't have a license in New York or New Jersey, feel free to disregard this. Again, the code word is pricing. And we'll move on to cost and pricing updates.
Okay, well, that was a clever transition. So pricing, and now we'll talk about cost and pricing, and specifically some case law updates relating to cost and pricing issues. We can move to our first case. So this case was covered fairly widely, I think, in the kind of government contracting sphere of, for those of you geek out on the Law 360 and client alerts, around Secretary of Defense against Pratt and Whitney. So this is a case that went to the Federal Circuit, originally started at the Armed Services Board of Contract Appeals, and then went up on appeal on a couple of critical issues. The background to it, it's a CAS 418, so overhead case, and it gets into a lot of the sort of intricacies of how Pratt and Whitney accounted for its supplier costs that really may not be that relevant outside of Pratt and Whitney. But it had a few kind of important takeaways around advance agreements, or what in this case were coined accounting practice agreements. So I think it's just helpful to talk a little bit about the background. The issue, and again, this is kind of the intricacies of Pratt and Whitney's accounting. Pratt and Whitney used a revenue sharing model. That's how it paid for supplier parts. So unlike what you might think of a conventional supplier relationship where a component of Pratt and Whitney's engines, it was purchased at a fixed price or even a cost basis to say, we'll agree and we'll buy the widget, the component from our supplier for X amount of dollars. Pratt and Whitney had a revenue sharing model. So what the collaborator is the term they used, but the supplier, what they were paid ultimately depended upon how much revenue Pratt and Whitney generated in selling those engines. And then you have an additional complexity. Pratt and Whitney, of course, supports both military and government contracts as well as commercial civil aviation. So they have an allocation methodology both to figure out what these supplier costs are and then to allocate those that ended up in overhead out between their government contracts and their commercial contracts. So ultimately, there was also another issue around what was called drag, which was basically, again, a term that Pratt Whitney had coined for how they were accounting for part of their overhead expenses. So they get into a dispute with the government over the proper accounting for each of these costs. Those go up to the Armed Services Board of Contract Appeals. They ultimately reach essentially a settlement with the government on a portion of the CAS 418 and have an accounting practices agreement on how they're going to continue to account for those costs going forward. And they have this issue again with drag, which is basically credits were being, whether they had to be offset, and that comes up in the case as well. So when it goes to the Federal Circuit, two issues are still in the case. I mean, some of it is this underlying accounting practice that again isn't really probably that interesting to those outside of Pratt and Whitney. But the two kind of key issues were how do we characterize different claims and the finality of those claims. So those are procedural issues that would be of interest of anyone kind of practicing in the government contracts world. And then a specific issue about the enforceability of these accounting practices agreements. So those are the two kind of issues that are up being dealt with by the Federal Circuit in addition to the actual accounting practice issues. We can go to the next slide. So the holding from the ASBCA was that there was a CAS 418 noncompliance in the way that had been articulated. But well, I'm sorry, I should rephrase that. So as I said, there was kind of a settlement that's agreed upon, and the ASBCA looked at it and said, we're not going to get into you have an agreement with the government on how we're going to deal with this accounting practice. That's going to bar the drag credit claim because you've agreed on how you're going to account for it. So when it went up to the Federal Circuit concluded that this accounting practice agreement was invalid for a variety of reasons, primarily because it didn't meet the specific requirements of an advance agreement. I think sort of in practice, it wasn't coined as an advance agreement. It's called this accounting practice agreement, but that's essentially what it sort of in practice was. It didn't meet all of the same formalities as a advance agreement. Specifically, it wasn't incorporated into current and future contracts. That was sort of the big issue that the Federal Circuit ultimately had. And so the Federal Circuit concluded we're not going to enforce it. So that's what had aided Pratt and Whitney winning essentially at the at the ASBCA and on review at the Federal Circuit. Federal Circuit concludes it's an unenforceable agreement, so that doesn't serve as your defense on the how you're accounting for these drag costs, which again you could think of as essentially credits into Pratt Whitney's overhead pool. This follows on, there have been a series of other cases that I think the key takeaway for kind of everybody operating in the government contract space is there has been a lot of pushback on the enforceability of advance agreements. This is sort of the latest and really rearticulates that any kind of settlement or agreement or resolution, best practice would be to basically adopt it and follow the 31109 requirements for an advance agreement, which is to reduce it into writing, which typically would be typical of settlement agreements, incorporate it into a current contract and continue to incorporate it into future contracts, and make sure it meets all of the various requirements. Prior cases, so it would have been not a hot topic from this year because it's a few years aged, have also looked at just this issue of government authority to enter into advance agreements. And just again, the kind of continuation is you have a contractor who believes they've reached an agreement, the government has signed off on it, and then in subsequent litigation, the government is, arguing, taking the position, and I can't really fault them. The Federal Circuit agreed with the government's position ultimately, but tried to distance themselves from the position that the contracting officer had taken. So I do think there is a fair degree of buyer beware a little bit, and ensuring all the T's are crossed and the I's are dotted when you're reaching any kind of agreement, because the government has shown a willingness to go back and challenge those agreements. And in this case, it had to do with the formality of whether it was an advance agreement. In prior cases, the government has said, look, what we agreed to in the advance agreement is clearly contradicted elsewhere in FAR or regulation, so it's a void. It's an illegal agreement. We can't agree to let you engage in an accounting practice that's clearly violative of CAS or some other provisions of the FAR. And again, the whole point of advance agreements is to try and resolve problems, to take thorny issues where the regulations are, difficult to fully ascertain or have some ambiguity or gray area around them, and enter into agreement. So I think this is probably the latest in a cautionary tale of trying to resolve agreements and ultimately whether they're going to be enforceable. And then we can go to the next slide. Kind of second issue that was being addressed is whether or not you had the finality of the agreement. So another piece the court looked at was the CAS 418 piece. So you have the drag, which is this kind of credit to overhead, and a separate 418 piece. The board concluded their case and retained jurisdiction over quantum. So they'd said, yes, there was a CAS 418 noncompliance. Go back and figure out the cost impact of it. And when the contractor appealed, the Federal Circuit said that's not properly before us because it's not a final decision. There isn't finality here. Quantum is still being resolved. For those of you who are kind of familiar or practiced, the Federal Circuit, that kind of idea of finality of an appealable order, if for those of, I think most of you are lawyers, I know not all of you are, just kind of think back to civil procedure days. That's a pretty typical standard out there amongst the district courts. You have to have a final order unless you have an exception for interlocutory appeal. But the Federal Circuit has long had a more prudential viewpoint, that they've said finality in the world of government regulation, which is largely what the Federal Circuit deals with, including with government contract issues, is a little bit more amorphous. So we're going to have a more prudential rule. And there are cases in which the Federal Circuit has said, we will go ahead and take the appeal. You have reached dispositively, board, a resolution of the legal issue, whether there was a CAS 418 noncompliance, rather than have the next years taken by figuring out the cost impact for then you will come back to us and appeal, and we might conclude there isn't a 418 CAS noncompliance in the first place. We'll take those appeals earlier. So that had sort of been the historical backdrop. Those cases haven't been overturned per se by this case, but the court did ultimately conclude they were not going to apply that kind of more flexible prudential rule on finality their view was because 418, the claim had not been resolved as to the amount of quantum that was in dispute, it wasn't ripe for appeal. So that can be a challenge for contractors, and I imagine for the government as well. Had in other cases where the government would ultimately be the party that would owe money, because that prudential review is helpful, right? You have a legal dispute and then a lot of effort on figuring out the impact of it. But if we can figure out who's right or wrong on the legal dispute, that's sort of the operative issue before we get into the dollars. So a couple of kind of key takeaways of this Pratt and Whitney case. And we can move to the next slide, please. So two more cases we have around the issue of some certain. So for FAR defines what a claim is, requires that it have a some certain. That has been essentially a requisite, some back and forth on whether that's a jurisdictional issue. Again, that's been kind of a hot topic, whether things that are in regulation and statute actually are jurisdictional or more just requirements that can be waived for equitable or other reasons. This case dealt more so with whether or not whether the some certain had been stated. GE sought a price adjustment under an economic price adjustment clause under its contract. And its initial request to the government was just a determination that it was entitled to an adjustment. It didn't specify the amount that it thought was due. It goes up, parties are with the contracting officer aren't able to resolve it, goes on to appeal at the Armed Services Board of Contract Appeals. And then through discovery process, the government now raises a defect and says you've never identified a some certain, so your claim is invalid. A couple of key takeaways. The board held one, it wasn't too late, even though it was in discovery, to raise the some certain issue. And another, I think probably more, I mean, that's procedurally, I think, interesting, but more relevant. GE had asserted that's fine, but our claim isn't a monetary claim. One of a claim can be monetary, and then you have to have a some certain. You can also have a claim where you are just trying to resolve an issue of contract interpretation, a non-monetary claim. And GE said that's what we have here. We've asked for the contracting officer and now for the board just to make a legal determination. Does this economic price adjustment clause cover our circumstance? That's just a legal question. We're not asking for a some certain yet. Once that's resolved, we can go forward and deal with it. And the board held, no, we don't view this to be a non-monetary claim if the real consequence is payment. And I think the only a reservation I have in my mind as a practitioner, in this area and who takes a lot of cases to the ASPCA is that's generally always going to be the case of a non-monetary claim. I mean, while you're still focused on some issue of contract interpretation, it's going to have some economic impact down the road. If it was just an purely academic exercise, you wouldn't, often pursue the claim. You're asking for a non-monetary judgment focusing on an issue of contract interpretation, but it's likely to have some financial impact in the performance. And I think this blurs a little bit that distinction. So again, it doesn't formally say no non-monetary claims ever. Court board recognizes there are such a thing, but says if what you're really the consequence of this would be payment, then you need to state a specific amount. So I think certainly a challenge and an issue that contractors need to be cognizant of. And we can move to our next slide. We have another case. Samho Enterprises had again another issue of what qualifies as a some certain. And here, and this kind of follows a continuation of cases as we note in the last kind of bullet points here. Samho in their claim said that they were entitled to a some certain of no less than a stated dollar amount. So they set sort of a floor. We know we're at least owed this amount, could be more than this. And the board concluded that fails to state a some certain. You need to have a specific amount that's being claimed. And there were other cases similar to that. So you've seen cases where contractors have used the phraseology no less than. So kind of a similar phrasing, or I'm sorry, you've seen around like approximately. Previous cases have said amounts like saying to be determined or in excess of. That kind of qualifying language have not met the requirement. Here again, no less than doesn't meet the requirement. And practically, this can be a challenge for contractors when either the damages aren't fully known or they're known, but there are moving bits and pieces to it where there could be some variability and figuring out how to address that. So again, the best practice is to identify as definitively as you can the amount. There are some cases that also talk about if you can't identify a particular amount, but you can identify essentially a formula saying this is how our damages absolutely would be qualified. That can also meet the requirement. But a couple of cases in this area just have been a handful of some certain issues coming up recently where that's been a focus area and some additional guidance in these two cases.
Next slide, please, Nick.
So we'll talk about some data rights developments in cases next. So we can move to the next slide. So two kind of issues to deal with in data rights. The first is a statutory requirement in the NDAA provided that DoD should go back and inventory its existing data rights and contractual requirements and establish a system for tracking them. Again, in practicing in this area and having these data rights issues come up, including in litigation when you're talking about who actually has data rights, either between primes and subs or between competitors or with the government. I mean, this issue of where do we catalog, how are contractors internally, and now this requirement for the government to catalog the data rights it owns and to ensure that a contract that it may have paid for data rights or had earned data rights or had data rights as part of its contractual provision from years ago. Now that technology may be being provided again subsequent to iterations of development over the years. Is the government essentially paying for it twice? Is it agreeing to something more restrictive when it already has unlimited data rights because it again paid for that development prior contracts? I think it's a thorny issue. It's something that's difficult to track. I think contractors struggle themselves, some more than others, but different degrees of maintaining this kind of inventory. And now the government is going to endeavor to set that up as well. And then a case update, Flight Safety International decided again by the Federal Circuit in 2025, dealt with commercial markings of commercial item data. So in this case, Flight Safety was actually a subcontractor, but had marked its data that were commercial items, so had marked its commercial items accordingly and said that they were proprietary and restricted. And one of the kind of nuances here was with OMIT data, which is instruction, training, operating, and maintenance data. So a type of data that's an exception where you have to give the government data so it can use the data to maintain whatever product they're being provided. And one of the issues, the government took the position that although it was commercial and no dispute it was developed at private expense, it met the definition of OMIT data. And one of the issues that came up in the case was, does that mean once it meets the definition of OMIT, you get unlimited rights to the data? That sort of OMIT data is unlimited rights. But is that unlimited right then restricted only for the purposes of using it for OMIT data? So the kind of nuance or rub there is you can have data that meets the definition of OMIT, so it has to be provided with unlimited rights, but then the government can use it for non-OMIT purposes. So it has so that was the controversy. The Federal Circuit ultimately sided with the government and said that Flight Safety's markings were improperly restrictive, that the government was right and had a mechanism to challenge them, even though they were commercial items. I also like to highlight this case both, for the reasons we just talked about, but also you can see in some of these decisions some of the tension with, on the one hand, a government emphasis of we really need to push commerciality, we need to broaden the tent, bring more companies into the fold, and engage with them on more commercial standards. And then you're seeing cases that still may serve essentially as cautionary tales for companies that aren't that familiar with government contracting, Flight safety is not one of those. I don't mean to imply that, but others who read are aware of that case to say, gee, this is still kind of fraught, even as a commercial item. I have my own markings. This is how I would mark and restrict my data in commercial settings. I'm still not permitted to do that. So you have that kind of incongruity, a little bit of on the one side an emphasis on this, and then some buyer beware kind of cautionary tales where contractors are still running into challenges even though they're in a commercial item setting.
All right, so we'll move into our section on cybersecurity and AI. We'll focus a little bit more on the CMMC program. A lot of these AI developments are relatively recent, and we're still seeing how they're going to turn out, seeing exactly what they mean. But we'll go through what's happened recently and what that might mean. So next slide, please. Thank you. The CMMC program was finalized last year. It became effective in November. A kind of significant step in the government's journey on enforcing cybersecurity requirements. The CMMC program is really focused on reporting and assessing where a contractor is in their cybersecurity capabilities. It doesn't, none of the three different CMMC levels uh, include substantively new security requirements. It's more a way of formalizing the method by which the government communicates to, and specifically the DoD communicates to contractors, what level of cybersecurity is required for the contract, how the contractor is going to assess itself or be assessed on whether it has met those cybersecurity requirements, and include some information about what types of documents and information the contractor is going to possess that demand certain security levels. So like I said, there are three levels to the CMMC program: level 1, 2, and 3. Level 3 is reserved for the highest level of security requirements. Level 2 is what the DoD has said it expects most contractors will be subject to. Um, the reason being that you're subject to level 2 if you are expected to process controlled unclassified information, or CUI, in the course of performing the contract. And CUI is becoming a lot more prevalent and being transmitted to contractors a lot more. And level 1 is the lowest requirement and is reserved for contractors who are only processing federal contract information, or FCI. The rollout of the CMMC program is phased. There are three phases. Phase 1 began in November when the CMMC program was finalized. During phase 1, only level 1 and level 2 CMMC requirements will be uh, put into new contracts. Level 3 will not be put into contracts yet. Another important part of of the first phase is that for level 2 requirements, contractors will be allowed to self-assess their compliance with level 2. Once phase 2 begins, uh, the DoD will be able to require third-party assessment of compliance with level 2 requirements. Level 1 is always can always be self-assessed. So that is the big difference between phase 1 and phase 2. And then phase 3, CMMC level 3 requirements will start being imposed, being required in contracts moving forward. Like I said earlier, CMMC program is not really about imposing new security requirements. The level 2 CMMC requirements are essentially the same security requirements that are currently required under certain DFARS clauses uh, for contractors that process covered defense information, which is in many ways the same as controlled unclassified information. So if contractors who are already handling and processing CUI, generally there aren't going to be new security requirements, but new reporting and assessing of compliance with those security requirements. Next slide, please. Again, a little bit more about the timeline and those implications. Self-assessments and SPRS, which is the system for self-reporting scores, assessment scores, need to be up to date. If contractors currently are subject to level 2 requirements and are self-assessing, they'll soon potentially be required to be assessed by a third party. Typically, contractors who have gone from self-assessment to third-party assessment have found that their systems aren't as compliant as they thought they were, and there are some things to fix. CMMC does allow a status essentially of we have identified that there are issues and we are working on them and will fix them when issues are identified. There's a 180-day, a 6-month period to fix those while you can maintain your conditional CMMC status. So that may be cause to reach out to a third-party assessor now and start an assessment and understand what plan of action may be necessary to get those scores up and into compliance for level 2 by the time that phase 2 of CMMC begins this November. Contractors who think that they may be subject down the line to phase 3 could start looking at what the phase 3 security requirements are. That's the one part of CMMC that imposes new security requirements, 15 additional security requirements over level 2 for contractors who are predicted to face advanced persistent cybersecurity threats. Because again, as the security requirements ramp up, the difficulty with complying with them ramps up as well. So it may be time to look forward to what those will be and start implementing them now. For level 3, compliance has to be compliance has to be assessed by the DoD itself. It has an office set up to do these assessments. And for level 3, those have to be assessed by the DoD. Next slide, please. So moving into AI developments, a lot of these have happened at the end of 2025 or in the first few months of 2026, but we wanted to include them because they're really kind of defining where the government's going with AI, artificial intelligence. So 2 key memoranda were issued, similar to some of the FAR and procurement overhaul executive orders that we discussed earlier. A lot of the memoranda right now are directed at kind of intra-governmental activity. The executive branch telling the DoD, what it wants to happen, what it wants to prioritize, and these memos are mostly focused on that right now. Next slide, please. So the Pentagon's artificial intelligence strategy, Secretary Hegseth delivered a speech outlining these again, signaling its intentions, signaling its priorities, but many of these things have not necessarily been moved into application to industry yet. Next slide, please. A new office has been created, the Chief Digital and AI Office, and it's responsible for operationalizing AI strategy. It serves as a go-between between some of these new innovation organizations that are being set up, such as the Defense Innovation Unit and the Strategic Capabilities Unit. There's actually 6 of these innovation execution organizations. And then these innovation insertion increments. Again, this isn't necessarily something that's going to be put into contracts. They're described as portfolio managed funding allocations, and they're not going to be implemented until FY 2028, but they are coming. Next slide, please. And then again, signaling some of its priorities and projects that are coming soon. The DoD released some information about some flagship projects, all related to AI, generally organized into these three groups: warfighting, intelligence, enterprise, directed by single program leaders that are supposed to be, again, using some of these recently refined and stripped down procurement processes to rapidly explore and deploy new technologies, especially when it comes to AI, which is developing very quickly. And capabilities that weren't there yesterday might be there tomorrow. So there's really a focus on reacting quickly to new capabilities. Next slide, please. Some takeaways. Again, we've kind of covered a lot of these. Flexible contracting vehicles are probably coming to, again, take advantage of rapidly changing capabilities, and some potentially changing evaluation criteria that focus more on speed and ability to use AI. Next slide, please.
Okay, well, our last couple of minutes, we're just going to catch up on a couple of bid protest items here quickly. Next, how about GAO trends? Ultimately, the sustain rate has stayed about the same, but fewer protests are being filed. So we're seeing some declines. I think the general thought is one of two things are happening. One, there's just a general decrease in protest activity, potentially because the government has moved to fewer but longer term acquisitions. So there are fewer opportunities to protest, some consolidation throughout industry. And also, though, we're seeing an uptick in cases that are being filed directly with the U.S. Court of Federal Claims. So you have a choice where you file protests. There's some different venues. GAO is one of them. We're seeing more cases go to the Court of Federal Claims. So just some kind of trends that we're observing. We can move to the next slide. A couple of key legislative changes. I think we've seen several provisions pertaining to bid protests over the years, generally, I would say reflecting somewhat of a congressional hostility towards bid protests, or at least a viewpoint that they're being used or misused, either strategically by incumbents or are just otherwise delaying the procurement process, I think to a view by some members of Congress unnecessarily. So two requirements in this last year's NDAA. One is an enhanced pleading standard at GAO. So already GAO has more than what most lawyers would refer to as like a notice pleading standard. Any sort of on information and belief will be viewed as a speculative protest. So this required an adoption of rules. So we'll see what actual rules get adopted. Applies to DoD protest only, at least as the statutory provision was written. We'll see if it gets broadened out. But GAO has said that it will look at proposing new rules that require credible and supported by evidence. And this is a challenge, right? I mean, when you're a protester, you have limited information. The government has often given you a debriefing that has said, some things, but you're having to make some inferences about what the government must have done in the evaluation. So, I mean, this potentially can be a challenge. Another one is a withholding and potentially a forfeiture. Again, for DoD contracts, if you are the incumbent and you protest to GAO, and the GAO dismisses your protest and says it lacks any reasonable legal or factual basis, you will lose a portion of the withholding that the government has made. There's a viewpoint and there's some strategy, and it's not an unfounded viewpoint that contractors, when they're incumbents, if you protest, you get an automatic 100+ day stay. So, why not protest? You're going to continue performing for at least another 100 days. That may more than pay for the protest. And if the viewpoint is if that's not a credible protest, there should be some economic sanction. And so that's what's being done here. Already there's a similar standard for recovering attorney's fees from the government. So if the government acts without a reasonable or factual basis, that's a pretty high bar when you're asking for fees from the government. we'll see if it remains as high of a bar when it goes the other direction. So stay tuned for that. And then our final, I think I have a few seconds still to end you perfectly on time. Bid protest case. Protester brings the case. Protective order is issued, so information is supposed to be freely exchanged within the protest, but the government would only produce redacted documents. And ultimately, GAO said, fine, in a sense, that's your prerogative, government, but because of the degree of the redactions, we can't validate that what you did was reasonable and otherwise in compliance. So we are going to sustain the protest. So a little bit of a one-off. I don't know how common that is. Typically, when you have a protective order, you're getting access to redacted information, but DLA chose to take a different approach here and ultimately ended up not working for them, and the protest was sustained. So sorry, it looks like I put everybody a minute behind schedule. That does conclude. I'm looking at the list. I see a handful of questions that we can address offline, and others are the pricing code. So appreciate everyone's attendance. If you still do have questions, again, please feel free to reach out. Appreciate everyone joining, and please stay tuned for our Q2 invitation, which should be forthcoming in probably the next month or so.